Hey folks, James Abrinio. I'm a Northern Virginia personal injury and criminal defense lawyer. It's Friday, and I decided I wanted to comment on a case that's been pretty insane to me. It's a pretty remarkable case, and I thought it was important enough to talk to. So, in this case, apparently Disney is trying to use the fact that the representative of an estate for a wrongful death claim signed up for a free trial for a Disney Plus subscription to force that wrongful death case into arbitration, which, as I say it, it's pretty remarkable. So the facts of it is really tragic. A young woman, a medical doctor, apparently went to a restaurant located at Disney Springs, which I understand to be some type of entertainment complex owned by Disney. On the website for Disney, there was representations apparently being made about all food there being allergy free. There was other apparent representations that she relied on in choosing this location in order to have a meal. And tragically, it turned out that the food was not allergy free. Apparently, she had an allergic reaction and tragically died as a result. In response, her husband, surviving husband, was appointed by the court to be representative of her state and filed a wrongful death claim, which is pretty common when there's a wrongful death claim. And we're talking about Virginia. This is not a Virginia case. But what I try to do with these videos is kind of relate this to Virginia. So in Virginia, if somebody passes away, the court has to appoint an administrator to bring forward that litigation. Here it was the husband. When he did that and he filed suit, apparently Disney realized that he had signed up for a free trial for a Disney subscription. And in those terms of service, apparently there's broad language there that essentially says that any and all claims that you may have against Disney shall be arbitrated. And remarkably, in response to that, the company is using this clause to try to essentially force the wrongful death litigation into arbitration. Pretty remarkable in itself. So what I thought I would try to talk to you about a little bit is Virginia law and just to think about this. And again, the first point being if there's a wrongful death claim, somebody has to be appointed administrator to the estate to bring the litigation. When you think about it in that context and what Disney is doing here, it makes it even that much more remarkable because the person that died, the person that was injured here, was the wife who tragically passed away. I'm not aware of any evidence that she signed up for these terms of service, that she signed any up for any free subscription, and so they're not even using something that she signed up for in order to force it to arbitration. Now, just to clarify, depending on how the wrongful death is brought, the benefactors or the people that suffered from that would be the estate. So here, I assume, obviously, husband would be one of the persons. But to use his alleged contractual agreement to a Disney subscription to prevent a wrongful death case due to injury to the wife is pretty remarkable. So that's something that I really wanted to point out. The other thing that I wanted to point out is a lot of times people will contact me and say, James, I want to bring a claim. The company knows that this is wrong. I think that they're going to be fair about it and they're going to do the right thing and ultimately make this right. I was injured because of their negligence or whatever the case may be. And so I trust the system. And this case shows that companies and lawyers and I'm not judging here, but they will take steps they need to do to protect their interests. And this case also shows that, at least in the eyes of the attorneys for Disney, an arbitration is a better position to be in than to have a jury of the peers of the victim's peers hear the case, because presumably they're thinking they would get a better result from an arbitrator than a jury. And just for if you don't know, arbitration is essentially a way to have a case tried, but instead of having a jury, and I'm not sure exactly how it's done in this state because every state's different. Either it's a judge or a panel of judges. They make decisions. It's not a full blown trial. There's different rules of evidence and things like that depending on the state and then the process. But long story short, the purpose of an arbitration is to avoid getting a case in front of a jury. And so that's clearly what Disney, in my view, is doing is they don't want this to be heard by a jury. If you've got a claim in Virginia, let's say you're suing a company and like for instance Uber, and you sign a terms of service that requires arbitration, they're going to try to do the same thing. They're going to try to force you to arbitration. Other companies will do that as well, and I think from a tactical standpoint, they've decided that's better off for their defense. Another point to be thinking about here is um, uh, while companies will do things that they think is in their best interest, in my view, from long-term standpoint, that may not be the best decision for the company. Companies often will do things, in my experience, that don't make a whole lot of sense. That if they just righted the wrong, it would end up saving them a lot of hassle and, frankly, a lot of money. Here, in my view, if Disney did the right thing, then it would be from a dollar's perspective, it's going to be a lot cheaper because I tell you what, I'm a big streamer. I like Netflix, I like Hulu. Um, I've subscribed to Disney before, but I can tell you as a customer, I'm not going to be signing up for them anytime soon. And I've got to imagine as this makes its way through the public won't use. I think I have a feeling this is going to take a hit. They're going to take a hit to their subscribership because people are going to see this as bad press. And if you're waffling on whether or not I should get this free subscription, so my daughter can watch the next Disney movies, if you're on the fence, those customers are saying no, in my view. So again, I'm not a business major. I'm not an MBA. I run my own business, obviously, but I am a consumer, and I buy stocks and own stocks and all that kind of stuff. Frankly, if I doubt Disney's watching, but if they care to watch, my recommendation, for what it's worth, as a consumer, is you're going to be losing a lot of money from us, because this tactic, it's cutthroat, and frankly, I think it's a wrong move to make. And again, this is not me giving legal advice as a lawyer to a company. This is me as somebody that likes Disney movies. I'm going to be starting to think about different things differently if that's the kind of games that are going to be played. So, if you have a claim here in Virginia, you have other questions, make sure to subscribe to this channel. We really focus on Virginia law and policy, personal injury, criminal defense, those kinds of things. But we do try to comment on interesting cases. This is an interesting case, but I also think that it's interesting because it's tragic. And I really just surprised the tactics being made here. If you have any questions, feel free leave comments, questions in the comment section, all that kind of stuff. Wish you guys the best. Be safe.